3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time we walked through Maxwell Trial Part 1. Today we are following Maxwell Trial Part 2 through the documentary records so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with defense strategy. That is where the paper trail becomes specific and testable.
It really is. It's the only place you can start if you want to understand the architecture of this trial. The defense strategy in United States versus Ghislaine Maxwell wasn't, straightforward denial.
Not at all.
When you audit the pretrial motions, especially from late 2020 to 2021, you see something else take shape.
Yeah.
It's a strategy built on procedural prejudice.
Meaning they weren't just arguing she was innocent of the facts.
Exactly. They were arguing that the very machinery of the court, the process itself, was making a fair defense impossible.
And we see that laid out in filing EFTA 000021730. This is where they frame the discovery process. It's usually a pretty dry part of any case.
Just handing over files.
Right. But here the language is, it's aggressive. They call it a war on evidence.
And if you look at the numbers, you can understand the tactic. The defense claimed they were given millions of documents, millions of pages of digital evidence.
Seized from Epstein's properties, Maxwell's own devices, servers.
The whole digital footprint. And their argument was that reviewing all that within the court's time frame was a logistical impossibility. They called it a due process violation. So
the argument becomes, you've buried us under so much paper, we can't possibly find the one document that proves our case.
Precisely. It flips the script. The mountain of evidence isn't presented as proof of a sprawling conspiracy.
It's presented as a bureaucratic weapon.
A bureaucratic weapon used by the government to prejudice the defendant. The logic is, if you can't read every single page, you can't prepare a perfect defense. Therefore, the trial itself is inherently flawed from the start.
This connects directly to that letter from defense counsel Bobby Sternheim. That's document EFT 00000289868. She uses some very specific language in that filing.
She does. She calls the allegations phantom in nature.
A phantom nature.
And that's a critical piece of their entire framework. Sternheim's point was that defending against a memory from, say, 1996 is a different challenge than defending against a bank robbery that happened last week.
A bank robbery has a timestamp. It has security footage.
It is a clear alibi. You were at dinner or you weren't. But with these allegations, the timeline was often vague.
Something like, in the summer of 1996.
Exactly. And how do you produce an alibi for an entire season 25 years ago? You can't.
It's impossible.
So Sternheim argued Maxwell was being forced to fight ghosts, to box against these phantoms. Without a specific date and time for each count in the indictment, the defense claimed they were at a disadvantage that no amount of document review could ever fix.
So they weren't just attacking the evidence, they were attacking the timeline itself, the very structure of the case.
It's an attack on the geometry of the case. If the points on the map don't have clear coordinates, you can't draw the line connecting them.
But the government's response to this was just the sheer weight of corroboration.
Yes, and that brings us to the next battleground. The 2016 deposition.
Right.
If any single document connects the phantom allegations to a concrete conviction, it's that deposition from the Giuffre versus Maxwell civil case.
The defamation suit. And that transcript was sealed for years.
It was. And the defense fought tooth and nail to keep it that way, filing motion after motion.
Because they knew what was in it.
They knew it contained the perjury trap. We have to be very clear on this. In that 2016 deposition, under oath, Ghislaine Maxwell gave categorical denials.
She didn't just say, I don't recall.
No, she denied any knowledge of Epstein's sexual activities with minors. She denied knowing specific underage girls were even present at the residences. Flat denials.
And years later, when the Southern District of New York files criminal charges, those denials become the crime itself.
They became the foundation for the perjury counts. The government's logic was simple. She lied under oath in 2016. We can prove, through flight logs and other testimony, that she was present. Therefore, she was lying about her lack of involvement.
And the document trail shows the defense strategy had to shift here. They weren't just trying to keep the deposition sealed to avoid public embarrassment.
No, it was more tactical than that. They were trying to suppress the names of the does associated with that case.
Doe 105, 107, 110, those were the names at the center of the litigation in Judge Preska's court.
Right. The defense was trying to prevent a domino effect. Their public argument was that unsealing these names would poison the jury pool, that the media frenzy would make a fair trial impossible.
But the real concern was corroboration.
The real concern was the pattern. If Doe 107's identity is revealed and they come forward with testimony that matches the accounts of Jane and Kate, then the phantom defense just collapses.
One witness is an anecdote.
2 is a coincidence. 3 is a pattern. And they were clearly trying to prevent that pattern from solidifying in the public record before the trial even began.
Which explains the intensity of their motions around the ransom files.
Yes, the motions regarding the accuser Sarah Ransom. This is a very specific maneuver you can see in the file release labeled 1332-16.
This is where the defense strategy gets into witness impeachment. It gets ugly.
It does. The defense, and in some filings, intervener Alan Dershowitz, moved to declassify a specific set of Sarah Ransom's own emails.
The bait stamps are ransom 0000000273 through 557.
And in those emails, Ransom makes some very sensational claims.
She claimed to have unhackable devices, video evidence involving very high-profile people.
Specifically, she named Bill Clinton, Donald Trump, Richard Branson. The defense's strategy was one of forensic disqualification.
Meaning?
They argued that if this witness is making these grand, almost conspiratorial claims about videotapes on unhackable devices, tapes that never materialize, then her core testimony against Maxwell must also be unreliable.
They wanted to paint her as a fabulist, a fantasist.
The exact words they used in the filing were inflammatory, salacious, and defamatory. The goal was to get those specific emails in front of the jury to say, look, this is the quality of the accusation you're dealing with.
So the hope was the jury would see these wilder claims and then discount her entire testimony.
And not just her testimony. The hope was that it would poison the well for all the accusers. It's a rotten apple strategy. If you can convince the jury that this one accuser is unreliable, maybe they'll conclude the entire barrel is suspect.
It's a huge gamble, though. You're basically asking the jury to ignore flight logs, to ignore other corroborating accounts, and focus entirely on these emails about spy pens and secret tapes.
It's a high-risk maneuver, but it may have been the only one they felt they had left. They couldn't plausibly dispute the flight logs, they couldn't dispute the photographs of Maxwell with Epstein, so they attacked the credibility of the people telling the story.
In the end, though, the jury didn't accept the phantom defense, and they weren't swayed by the impeachment strategy.
Which brings us to the verdict.
Yes, the verdict. The record is clear. A conviction on 5 of the 6 counts.
And it's important to be precise about what those counts were. It wasn't just a generic guilty verdict.
Not at all. The specifics are what matter for the audit. She was convicted of sex trafficking of a minor, conspiracy to commit sex trafficking, and transportation of a minor for illegal sexual activity.
These are logistical crimes. They're operational.
That is the key. The jury's verdict wasn't a moral judgment that she was a bad person. It was a factual finding that she was a manager, that she ran the operation, she arranged the travel, she paid the victim, she maintained the schedule. She was a facilitator in a criminal conspiracy.
But there was that one acquittal, count 6, enticement of a minor to travel to engage in illegal sex acts. When you dig into the trial transcripts, what was the likely reason that single count failed?
It boils down to a very fine point of law and the timeline. The statute for enticement is very specific. It's not the same as transportation.
It's not. For an enticement conviction, the prosecution has to prove that the illegal sexual act was the intended purpose of the travel from the very beginning. The intent had to exist before the travel started.
So if a victim was recruited under a false pretense, say, for a legitimate-sounding job, or to attend a school, and the abuse only happened after they arrived,
then the specific legal element of enticement to travel isn't met. The abuse is still a crime. The trafficking is still a crime. But that particular charge of inducing them to cross state lines for that specific illegal purpose falls short.
it suggests the jury was being incredibly methodical. They were looking at the moment the recruitment happened, the point of sale, so to speak.
It does. And in a way, the acquittal on count 6 actually strengthens the convictions on the other 5. It shows this wasn't a jury driven by emotion or public outrage. They weren't just rubber stamping a guilty verdict. They were carefully auditing the legal elements of each individual charge. They looked at the evidence and concluded it perfectly supported transportation and conspiracy, but that there was a reasonable doubt on the specific element of enticement in that one instance.
You mentioned the flight logs a few times. The source document is 01 Epstein Flight Logs.pdf. How, in a legal sense, did the verdict transform those logs from simple travel records into criminal evidence?
On its own, a flight log is neutral data. It just shows a specific aircraft flew from point A to point B on a certain date with a list of passengers. It proves movement, nothing more.
But the verdict connected the dots.
The verdict was the legal act of triangulation. It took the victim testimony, the names in the little black book, and the flight logs, and it wove them together.
So when a victim testifies, I was flown from Palm Beach to New York that summer and I was abused.
That's a statement. But when the flight log for that exact date shows the names of that victim, Epstein and Maxwell, and the passenger manifest, the log is no longer just a travel document.
It becomes the instrument of the crime.
It becomes the proof of the transportation of a minor charge. It's the physical infrastructure of the trafficking operation. The defense tried to frame these as social trips, just friends flying together.
The jury didn't see it that way.
The jury's verdict legally recategorized those trips. The logistics, the flights, the scheduling of massages, the hiring of drivers were converted from mundane activities into the elements of a crime. The flight logs became the documented skeleton of the conspiracy.
Let's move to the sentencing. The final number was 20 years, but the documents show a huge chasm between what the government was asking for and what the defense was proposing.
An enormous gap. The government, in its sentencing memorandum, requested 30 to 55 years. They were pushing for a sentence that was, for all intents and purposes, a life sentence.
On what grounds?
They argued her role was indispensable, that Epstein's network could not have functioned on the scale that it did, for as long as it did, without her as the primary recruiter and facilitator. They saw her as a co-architect of the entire scheme.
And the defense's request?
They asked for something in the range of 4 to 5 years. If you read their sentencing memo document, EFTA 000001A572, it's a fascinating document. They lean on her age, she was 60 at the time, and her potential safety in prison. But the core of their argument was about her pretrial confinement.
This is the Bureau of Prisons argument, the conditions she was held in.
Correct. We have filing EFTA 0000015902, which details these complaints. The defense documented her conditions at the Metropolitan Detention Center in Brooklyn. They cited extreme isolation, 24-hour surveillance.
And the flashlight checks every 15 minutes.
Every 15 minutes, all through the night, an officer would shine a flashlight into her cell to confirm she was still alive, still breathing.
The defense argued this was essentially punitive.
That was their exact argument, that she was being punished before she was even convicted. They claimed that because the Bureau of Prisons had failed so catastrophically with Jeffrey Epstein,
allowing him to commit suicide in their custody.
Right. Because of that failure, they were massively overcorrecting with Maxwell. The defense characterized it as a kind of torture designed to prevent another public relations disaster for the BOP.
Sleep deprivation, constant stress, isolation.
That was the picture they painted. And they argued that the judge should consider that incredibly harsh time she had already served as a mitigating factor and reduce the ultimate sentence accordingly.
Did Judge Nathan address that argument in her decision?
She did. The court acknowledged the conditions were severe, and Judge Nathan was critical of the BOP's handling of it. But ultimately, she found that the sheer magnitude and depravity of the crime outweighed those mitigating factors.
The crime was just too severe.
The crime, which spanned more than a decade and preyed on vulnerable children, was deemed so significant that a harsh sentence was warranted regardless of the prison conditions. And so she handed down 20 years.
Were there also financial penalties?
Yes, a fine of $750,000 and forfeiture of assets. But the 20-year sentence is the key. Given she was 60, it functions as the life sentence the government wanted. The defense memos argued repeatedly that any sentence over 10 years was effectively a death sentence. The judge gave her double that.
So let's use the documents to reconstruct the timeline that led to that sentence. The conviction covered a pattern from the mid-90s to about 2006. The Palm Beach Police Department files are essential here.
This is where the forensic audit really begins to show its value. If you want to see the system in operation before it became a massive federal case, you have to look at those probable cause affidavits from 2006 from Chief Michael Ryder's department.
And what you see in those affidavits is what you call the massage protocol.
It was not random. That is the most important takeaway from those files. The documents show a standardized operating procedure. It was a system.
It started with the massage appointment.
Yes, that was the entry point.
Yeah.
It was designed to be disarming. A teenage girl is offered a chance to make a few $100s just by giving a massage. It sounds safe. It sounds legitimate.
But the transition from that to assault was scripted.
The documents from 2005 and 2006 show that the protocol was fixed. It followed the same steps with the same language across multiple victims. This wasn't impulsive behavior. It was a routine. It was a practice methodology for abuse.
The documents also show how victims were turned into recruiters.
And that's the conspiracy element of the conviction in action. The files reveal a pyramid-like structure. A victim would be abused, and then she would be incentivized with money, with gifts, with praise to bring her friends into the fold.
Find us more girls.
It was a core part of the operation. It wasn't just Maxwell and Epstein acting alone. They weaponized the victims themselves to expand their network of targets. It was a self-perpetuating system.
And you can actually map the growth of the system using the flight logs.
You can. If you take the timeline from the Palm Beach police affidavits and you overlay it with the Epstein flight logs, you see the geographic expansion. Palm Beach, New York, the ranch in New Mexico, the island, the U.S. Virgin Islands. The logs provide documentary corroboration for the victims' accounts of being moved around the country.
Can you match specific dates from the logs to specific allegations?
In several instances, yes. A victim might testify about being abused in New York over a particular weekend in, say, 2001. You can then go to the flight logs and find a record of Maxwell and that victim flying to Teterboro Airport in New Jersey the day before.
And that destroys the phantom defense.
It completely dismantles it. It's no longer just a vague 20-year-old memory. It's a memory that is anchored to a time-stamped official flight record.
Which brings us to perhaps the most critical part of this audit, the institutional decisions. We've documented the crime and the conviction, but the documents also tell a story about why it took so long.
Why did it take from 2006, when the Palm Beach police were investigating, until 2021 to secure a conviction? The answer lies in the decisions made by institutions.
And the first and most important document there is the Ryder letter.
The Ryder letter, May 1st, 2006. From Palm Beach Police Chief Michael Ryder to the State Attorney Barry Krischer.
This is a document you almost never see.
You don't. It's a formal, written record of one law enforcement official expressing profound distrust in another. It's a devastating document for the State Attorney's Office.
Ryder writes, and this is a direct quote, "I continue to find your office's treatment of these cases highly unusual."
Highly unusual. In the very careful, polite language of interdepartmental memos, that is a scream. It is a siren.
He wasn't just questioning their judgment, he was documenting it.
He is building a paper trail. He goes on to explicitly request that Krischer's office disqualify itself from the case. He urges Krischer to examine the unusual course that your office's handling of this matter has taken.
So this document proves that the common narrative that the police botched the investigation is incorrect.
It is completely demonstrably incorrect based on this letter. The police did the investigation. They had over a dozen victims. They had probable cause affidavits. They had the evidence in 2006.
Ryder handed them the case.
He handed it to them, and they refused to prosecute it fully. The failure was not investigative. It was a prosecutorial decision. A calculated choice was made by the State Attorney's Office to block a full prosecution. That letter marks the point of origin of the institutional failure.
And that failure leads directly to the 2008 non-prosecution agreement, the NPA.
The now infamous NPA. The document source is 10# Epstein Plea Deal 2008.pdf. This agreement, signed by the U.S. Attorney's Office in Miami, is unique in the federal record.
Because it didn't just protect Epstein.
It was drafted with a specific clause to protect any potential co-conspirators.
That phrase, potential co-conspirators, that's the shield.
That was the legal shield that protected Ghislaine Maxwell for more than a decade. For years, that federal document was interpreted as a grant of immunity to the entire network. It essentially said, this case is closed, not just for him, but for everyone involved.
And this created a jurisdictional nightmare.
It did. The state of Florida refused to prosecute fully in 2006. Then the federal office in Miami signed the NPA in 2008, creating this legal vacuum. It took 12 years for a different federal jurisdiction, the Southern District of New York, to find a way around that agreement and bring new charges.
So the delay wasn't about a lack of evidence.
The evidence was there in 2006. The delay was the direct result of a jurisdictional deadlock created by that 2008 agreement.
Let's turn to the final institution, the Bureau of Prisons. The documents released about Epstein's death and Maxwell's subsequent management tell another story of failure.
They do. The source, Here are all the newly released Epstein files from the Bureau of Prisons, contains internal BOP emails and records. We see emails from an associate warden specifically asking to be kept in the loop on Epstein.
So there was awareness at the highest level.
There was absolute high-level awareness. This wasn't some unknown inmate. The administration knew he was a high-profile, high-risk individual. And yet, the same records document the cascade of failures on the ground.
The broken cameras, guards asleep at their posts, falsified logs.
The discrepancy between the high-level concern documented in the emails and the ground-level incompetence is staggering. It establishes a clear pattern of institutional negligence.
And that pattern of negligence is what Maxwell's defense team later used in their argument for a reduced sentence.
Exactly. They argued the BOP couldn't be trusted to keep anyone safe, and their over-the-top methods with Maxwell were proof of their incompetence.
We've covered what the documents show. Now we have to address what they don't show, the unresolved gaps in the record.
The first major gap is the Does. We talked about the unsealing orders in the Giuffre versus Maxwell case, but the identities of Doe 105, 107, and 110, among others, remain under seal or are still being reviewed by the court.
And what that means for the public record is?
It means it's incomplete. There are individuals whose stories and potential testimony are known to the court, but are not known to us. We have the redaction logs that prove they exist, but we don't know who they are or what they know. They are holes in the data.
The next gap is the missing tapes.
A very significant gap. Multiple affidavits, including the one from Maria Farmer, describe extensive, sophisticated video surveillance systems in Epstein's residences, cameras in bedrooms, hallways, common areas.
But those tapes were not part of the trial record in United States versus Maxwell.
They were not. Various discovery filings mention FBI's confiscated tapes, so we know tapes were seized, but they were never introduced as evidence.
Where are they?
We don't have documentation for that. There is no public chain of custody log that shows where those tapes ended up. The trial had to proceed based on testimony and logistical records like the flight logs. The video evidence, which witnesses swear existed, remains a black hole.
Finally, there are the names in the black book. The unredacted version is out there.
It is, and it's essentially a Rolodex of the global elite. Politicians, financiers, scientists, royalty.
But we have to apply a crucial distinction here.
We do. Being in that book is not proof of a crime. It is a contact list, nothing more, on its own. The unresolved gap is the almost total lack of investigation into why those names are in the book.
There are no interview reports for most of them.
For the vast majority, no. We don't know the nature of the relationship. But there's a more specific gap that has emerged from newer document releases.
The meetings that took place after Epstein was a convicted sex offender, after the 2008 Florida plea deal.
Correct. This is critical. These aren't just names in a book from the 1990s. The documents show scheduled meetings recorded in Epstein's calendars post-2008.
With people like Catherine Rimler, who was Obama's White House counsel,
and the current CIA director, William Burns, Professor Noam Chomsky. These meetings are documented. The gap is the context. Why was a convicted sex offender meeting with these people? What was the purpose? What was discussed? We have the calendar entries, but we have no sworn testimony about the substance of those meetings.
Let's synthesize this all. We have the verdict, which was decisive, and we have the institutional decisions, which were obstructive.
When you connect those two, the conclusion is unavoidable. Ghislaine Maxwell was convicted by a federal jury in 2021 based on a pattern of evidence that was, for the most part, available and known to the Palm Beach Police Department back in 2006.
The writer letter is the proof. He knew.
He knew, and he documented his concerns. The timeline shows that the defense's strategy of delay and obfuscation, the phantom arguments, worked for 15 years. And it only worked because it was enabled by the 2008 non-prosecution agreement.
The conviction finally happened only when a different part of the federal system, the SDNY, decided to bypass the institutional roadblocks that were put in place years earlier.
That's right. The system failed for 15 years. The documents prove the crimes were known. The delay was a choice made by institutions.
Next time, Victims' Compensation Fund.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.